Hello again, welcome to our Company Law Lecture Series. My name is Ayub Okayo, and today we shall study our second lecture topic on the formation of companies in Kenya. Under this topic, we shall explore step-by-step procedure for the company formation in Kenya, right from the promotional stage, the necessary documentations that are required for the registration of a company in Kenya, the consequences of registration of a company, and finally, we shall discuss the lifting of the corporate veil. So, welcome. Let us now learn together this chapter on the company formation. Now, before a company is formed as a corporate person or a corporate body, there are those stages that precedes its incorporation. Those stages are referred to as the promotion stage. And a promotion is conducted by the persons who come up with an idea of forming that company and takes the necessary steps to actualize that by making sure that the company is registered by the registrar of companies. So they will do all the paperwork or the preparations and enter into any pre-incorporation contracts to make sure that this company is brought into an existence. Although there is no statutory definition of who a promoter is under the Kenya's Company Act of 2015, some case laws offer insights on who a promoter is. In Ty Cross versus Grant 1879, Lord Cockburn defines a promoter as that person who undertakes to form a company and takes the necessary steps to make sure that that company is incorporated. Similarly, in Emma Silver Mining Company versus Lewis 1880 case, the court also notes that a promoter involves the idea of exertion for the purpose of getting up and starting a company. Although this case laws does not offer a distinction, or rather does not offer the relationship between a company and a promoter, it only shows us the relevance of a promoter who takes the necessary steps by making sure that there are all necessary documents and all the steps have been followed to make sure that a company is registered by the registrar of companies. Now, it's important for us to look at what are the promotional acts that usually precedes incorporation of a contract. So a promoter will make sure that they prepare the memorandum of association of a company and also make sure that they prepare the articles of association of that company. So if I may distinguish the two, the memorandum of association of a company is that document that defines the purpose, the objective, and the scope of operation of that particular company and its relationship with the outside world. So, if a company has been constituted as a financial institution, then all its businesses and how they are going to be conducted will be documented in the memorandum of association. On the other hand, the articles of association is the constitution of that company, and it is the document which is used to govern the internal affairs of that company, especially on day-to-day running of the business, and it looks at the conduct of those who run the company from the inside, including the directors, the managers, and all those in authority. So the Articles of Association is that document that acts as the constitution of a company that sets the boundaries of internal operation or internal management of a company. The Promotional Act also extends to appointment of the first director. So the promoters, before a company comes into an existence, they will appoint the first directors. We'll discuss more on the directors and how they're appointed and how the first directors um, are supposed to or to be vetted or the qualification that are supposed to be looked at when we're dealing with the topic on the directors. The promoters also make sure that they prepare the prospectus. So the prospectus is that, and it's like an advert for um, the people who wish to subscribe towards the capital of that company. So the prospectus is prepared by the promoters and is sent out for those who wish to subscribe to the capital of that particular company, whether it's a debt capital or equity capital in terms of shares or debentures. Um, so we also have the pre-incorporation contracts that uh, that a company may there's some contract that before a company is formed, the promoters may enter into some preliminary contracts or pre-incorporation contracts. Those contracts may be to assist the company for it to start. For example, it can be with relation to buying land for that company, or maybe buying some assets of that company, maybe a vehicle, or maybe building a structure for offices of that particular company, or even leasing the space where that company is going to be headquartered. And these kind of contracts are entered into uh, by the promoters, and they are not entered as um, they are not entered into on behalf of the company, as we will see in the next segment. So the promoters also make sure that they pay for preliminary expenses, pay some workers. If it's a construction, they can pay for those who are doing the building construction. There may be those other expenses that come along with it that requires to be offset before the company even comes to an existence. So the promoters will make sure that they do the payment for those expenses. Um, the promoters also provide for the capital, which will help the company to start running. So, and this is not the share capital, it's just the money which will be used to start the business in several ways. So, in case there is need for a capital at that stage before a company comes to an existence, then the promoters will be responsible. And finally, the promoters also make necessary steps to make sure that they have all the documentations required, they have followed all the procedure required for the company formation. So they will put all that together and submit to the registrar of companies to register the company. So, what is the legal position of a promoter? So, the promoter is not an agent of the company and is not a trustee of the company. As it was deemed in Kellner versus Baxter, 1866, it is as it is important for us to understand that an agent of a company will be acting on behalf of the company. And the time when the promoters are doing this, the company is not in existence and does not have the capacity to even bring those promoters on board. So does not have an any capacity to contract with these promoters or any other pre-incorporation contract. So at that time, we cannot deem the promoters to be either an agent of the company or a trustee of the company. However, in Elanga versus New Sombrero Phosphate Company Limited, the court opined that promoters are bound to the fiduciary duties of a company with regards to any activities that they do before a company comes to an existence. We'll look at those fiduciary duties in another slide. Now, fiduciary duties that are that the promoters are obligated. to comply with is in relation to their interests and good faith within that particular company. So they have the fiduciary duty to act in good faith and to the best interest of the company in its formation. So they cannot go outside that. They also have duty to account for any finances as how they are operating the company. How they're operating before the company comes to an existence. So they will have to account for any money or finances that have been channeled towards the formation of that particular company. Let's say, for example, if there was money meant for buying maybe an office space for that company, they will have to account for it. And they should not do it in bad faith, or they should not do it to their own uh, interest, but rather they have to promote the best interest of the company. They also have a duty to disclose if they have a personal interest before the company is formed. They have to disclose such kind of personal interest during the formation stage of a company. There are also several duties that come along with this under the common law. And one of those duties is that they must settle on the name, the company name. Of course, they will propose three to five names and put it in the order of their priority. So the company name, they will suggest which name to be used by that particular company. They will also prepare the constitutive documents, like I've said, documents like the Memorandum of Association, the Articles of Association, and all other documentations that are required to register a company. They are also under a duty to make sure that they cause registration of that company. So they have to make the formal application for that registration of a company. Promoters are also under a duty to make sure that they meet the company's preliminary expenses. And as already said earlier, that there are those expenses that may be required to be settled before a company comes into an existence. So the promoters are under that duty to make sure that they meet those preliminary expenses. Um, Also, they are under a duty to secure the first directors of a company. So they have to identify and make sure that they secure the services of the first directors. It, at this point, it's also important for us to note that promoters are not entitled to remuneration for any pre-incorporation uh, expenses or contract that they enter into. They are not supposed to be remunerated, and they are not supposed to be to recoup these expenses. However, in most cases, as a general practice, articles of association normally incorporate, or rather, they normally insert in the articles of association before the company is registered that the promoters can recover the expenses which they incurred during the incorporation stage. What about the pre-incorporation contracts? Let's look at this in much details. Before a company comes into an existence, there are those contracts that may be so necessary for the promoters to enter into. As we already said, it can be leasing for space where the office for the company will be, or maybe the premises where a factory is going to be built, or the buying land, or maybe building a structure and things like that. If the pre-incorporation contracts have been entered into, then such contracts will not be deemed to have been entered into on behalf of the company, because the company at that time is not um, with the capacity to contract, and thus any pre-incorporation contract is not subject to the company after it has been incorporated, unless otherwise, in some instances, like we'll see in the next slide, in um, uh, some of the exceptions to this general rule, that pre-incorporation contract does not bind the company itself. It's a contract between the promoters and that other party, but not with the company itself. So no one can purport to have entered into that contract before the company comes to into existence. No one should purport that they have entered into that contract on behalf of the company, because the law does not recognize any activities done on behalf of the company before the company is fully incorporated. Section 44 of the Companies Act of Kenya 2015 um, notes that a contract that purports to be made by or on behalf of a company at the time when the company has not been formed has effect subject to any agreement to the contrary, as a contract made with the person purporting to act for the company or as agent for it, and the person is personally liable for the contract accordingly. So whoever enters into that contract is liable accordingly, unless otherwise to some extent, where a company may be held liable, as we'll see in the next slide. So, what are rules governing pre-incorporation contracts? There are several rules that govern pre-incorporation contract, and one of them is that a company um, does not have the capacity to contract before its incorporation, and that's according to Kellner versus Baxter, 1866. Another rule is that a person who purports to contract as an agent in the pre-incorporation contract will be personally held liable for that particular contract. So if you purport to enter into a contract uh, with a company through a promoter, then you can only sue the promoter, but you cannot sue the company if the contract is not fulfilled according to the agreement. So if the contract is the terms of a contract have been violated, then you cannot say that you you can sue the company, because you can only bring the person who purports to contract as an agent of the company to an account, but not the company itself. It's also important for us to know that under the common law, any contract which is entered into by non-existing person is void. That means in the event that you entered into the contract purporting to be a contract with a company which has not come into existence, then such kind of a contract will be void. And that is according to the Newborn versus Sensolid GB Limited, a case of 1954. It's also important for us to note that a company cannot ratify a contract which was made before it came to an existence, because it did not have the capacity. So you cannot purport that once the company now has come into an existence, then it will automatically ratify what was done as what the contract which was done earlier as part of that company's liability. So the case of Natal Land Company Limited versus Pauline Colliery Syndicate indicates, rather, shows that a company cannot ratify a contract that was made before its incorporation. On the same note, Um, in the event that a company has entered into the similar contract as what was entered into before it was incorporated, so it was incorporated, um, I mean, the contract was entered into earlier, then once it comes in, when the company is now fully incorporated, it enters into this similar contract like the one which was entered into before it was incorporated, then it will be binding on that particular company. And that is an exception to the general rule. So if the company has entered into a new contract which is similar to the contract which was entered into by the promoters, then such kind of contract will be um, a good contract and to stand the test of the law. And that's according to Howard versus Patent Ivory Manufacturing Company. Lastly, under the rules governing pre-incorporation contracts, it's also important for us to know that even if the directors of a company adopts or confirms or reaffirms any contract which was entered into before the company comes into an existence, it does not create a relationship between that party and the company. So it will still go into the pre-incorporation contract, which binds only the promoter and the other party and does not affect the company, even if the directors will purport to adopt or um, to maybe confirm to that particular contract which was earlier entered into. So the law does not allow that does not allow ratification of a contract by the directors, a contract which was entered into before incorporation of that company. And that's according to North Sydney Investment and another versus Higgins and another. So let us now look at the typical formal procedure of formation of a company in Kenya. Under Section 11 to 17 of Companies Act, it provides for um, the procedure on how a company can be brought into an existence in Kenya. Section 11 notes that one or more persons who wish to form a company may subscribe their names to the memorandum of association and comply with the relevant requirements with respect to the registration. So two or more people come together and subscribe to the memorandum of um, association to form a company. However, under the same section 11.2, a company will not be registered if it's being formed for an illegal purpose. The same section 11 also shows that there are several registration documents that must be lodged with the registrar of companies. And those documents, I had highlighted some of them, including the application for the registration, the memorandum, the articles, among other documentations. Now, what is the formal procedure for a company formation? An application for the registration must state the following things. One, the name of that company or the proposed name of that company. It's just a tentative name. But those tentative names have to be at least three or 3 to 5. So you have to list at least 3 names and at most 5 names and in order of priority on how you wish them to be picked. If one fails, then they pick the second. The second fails, they pick the third, something like that. So it has to go in the order of priority. Then it has also to capture the location, especially for the registered office. The application must also show the liability of the members of that company. Is it a limited liability company or is it an unlimited liability company? If it's a limited liability company, is it by shares or by guarantee? So it has to indicate. The application must also indicate whether it's a private company or it's a public company. If it is a company which um, which has shareholding as a share capital, the application of this must indicate the statement of capital. It must indicate the initial shareholding, the nominal values of the capital, or rather the shares, aggregate nominal value of shares, the total number of shares which are to be subscribed. It has also to show the classes of shares. If there are several classes, we discuss about the classes of shares and much of this in our topic when we look at shares of a company. And that's according to Section 14 of the Companies Act. All these requirements on the share capital, capital statement, and all those other requirements with regards to the limited liability partnership, limited liability company made by the shares or the shareholding must be fulfilled. They must indicate all those under um, the registration. Now, if it's by guarantee, the application must indicate that this is um, a company limited by guarantee, and they must provide a statement for um, how much on guarantee has the members guaranteed that in case of insolvency of this particular company, they are standing in to meet the liability of a company for how much in terms of cost or in any part of the guarantees that they provide to that particular company. And that's provided for under Section 15. Section 16 requires that there be the proposed officers. So the proposed officers for that company before it's formed will be maybe say the company secretary, the initial directors, some managers, maybe an accountant, and some kind of professional um, uh, officers who will take the charge at the moment the company is brought into an existence. So let's now look at the formal procedure and how we start. Where do we start? We go to the business registration service platform. That's online. You have to do this online. So you go to business registration service platform under the eCitizen account. You go in there into eCitizen, then go directly to business registration service platform. Then you will click on uh, you'll click on that and then log into your business registration service. If you don't have account, you have to create one. Then once you're done with that, you will click on the make application. But by the time you're clicking on make application, you are either clicking on the public limited company or private limited company. So you have to select at that point. You must indicate um, the proposed name, and of course, as I said earlier, 3 names on the minimum and 5 names on the maximum on the order of their priority. Initially, we used to have the name search, but right now we do not have the name search. You just provide those names at the same time when you're doing the registration. If the registrar to look into that and then uh, see whether the name qualifies or stands the test to be registered as a name of a company in Kenya. Then once you've done that on that platform, you will now proceed to upload some documents. Some of those documents will include the articles of association, the memorandum. Then um, there are those other requirements that you'll have to upload according to how the type of company that you want to register. Once you've done that, once you have put the required documentation, you will now receive details. You will now receive details on how to execute those documents. So you receive those details on specific relevant documents, and then they will be out for you to print out and then sign on them and then proceed to the next stage. So there are those required inputs that we have already said you put on that particular website. One of which it is the articles, then the memorandum, the registered office, the proposed names, the name of directors, the beneficiary owners, all those things you're going to key them in that one platform. And once now um, you have finished to execute those documents, you will upload those forms and now pay the statutory fee for the registration of the company. The same on the platform. These days you can register using M-Pesa. You rather you can pay using M-Pesa, or you can pay using um, um, other methods, including banking options. So the various forms for application are found on this website, so you can go directly to that website. Now, once you've already done this and uploaded all the executed forms and also paid the statutory fee, then the registrar will now assess and look at all those documentations if they stand the test. If the registrar is satisfied that the application complies with the requirements of the Companies Act, will issue you with a unique number for that particular company and go ahead to issue a certificate of incorporation, which will state the name of the company, identifying number, will also indicate the date of incorporation, whether it's limited liability or unlimited, public or private, will indicate that. Now, at the end of this process, the registrar will now issue you with a signed certificate of incorporation, which is duly authenticated by the registrar's official seal. So that certificate, once that certificate has been issued, we say that a company is now duly registered as a body corporate, and it can now have um, the rights and duties as a body corporate. Now, what are the consequences of incorporation of a company? Section 19 of the Companies Act provides for the um, consequence for the incorporation. So the moment a company has been issued with the certificate of registration, then that company becomes the body corporate, and that means it can now sue or be sued. It can own property. It can now have rights, and it can also have duties and obligations. So the moment it is the certificate is issued, certificate of incorporation is issued. The moment that certificate of incorporation has been issued, then the company detaches itself from the promoters and now starts to operate solely on its own behalf. So those who were initially proposed as his initial officers will now take office. Um, those who are proposed as directors will now take office and operate within the boundaries of the memorandum of association and then the articles of association. So let's look at other fundamental consequences of incorporation. So once this company has been incorporated, it will be issued with a certificate like this, something like a certificate of incorporation, then says the name, number, and all those things, and then we have the barcode here, which is always unique from each from one company to another. They are always unique in identifying a company. So the company will now be an independent company, and it can now manifest on its own self. And that will be through a limited liability. So we will say now, if it's a limited liability company, now the subscribers or the owners of the company, those the shareholders of the company, will be only limited to their capital subscription, and anything that happens thereafter will be um, governed by the um, the Companies Act. So the company will now have its perpetual succession. That means even if one member dies, the company will still exist. Um, it can now own property, it can sue, it can be sued, and at the same time, it will have the capacity to enter into contractual agreement. And that's why now those contracts that were entered into before it was incorporated will not have much force on the company unless otherwise in the exceptional circumstances as already mentioned earlier. But uh, by the time it is now issued with this certificate of incorporation, it means it has the capacity to enter into any contract. Now, what about the lifting of the corporate veil? As we already seen in our first chapter, that there are two major principles of company law. One principle we say is the limited liability principle. The second principle we said it's a separate legal personality of a company. So when we're looking at the lifting of the corporate veil here, we're looking at the separate legal personality of a company. So we are attacking the separate legal personality of a company when we lift the corporate veil. Remember, once a company has been formed, it means that anything that the company does, it's liable on its own. We cannot again go back to the shareholders again to look deeper into some other things. We now disassociate with that and now hold the company liable for any of its own actions. Of course, its own action through its agents, like the directors or maybe the managers or any other employee of the company. So the company will be generally liable for everything. But this separate personality that distinguishes the owners from the company itself to some extent may be attacked. So there is a veil in between. It's like a wall in between that shields the owners of the company from any actions of the company. But there are instances when we may require to see beyond this company what else lies ahead of that. For example, if a company is involved in fraudulent dealings, maybe some shareholders are using this company wrongly to maybe defraud or maybe conduct illegal businesses, then we will lift the corporate veil. We will demolish the wall that stands in between the owners and the company itself. So, doing that, we call it lifting of the corporate veil. So, there's that veil of incorporation that we say a company is separate body. If it is wrong, deal with it as it is. If it has an issue, it will go to court on its own. But there are instances when we will disregard that corporate personality part and look beyond that incorporation or that separate legal personality test. The case of Salmon versus Salmon is very instrumental for us to look into this uh, corporate personality when we are lifting the corporate veil. In that case, it outlined that the company becomes a legal person separate and distinct from its members and managers. It becomes a juristic person with independent legal existence. And as it is, that's what we call, that independence is what we call the veil of incorporation. As a general rule, we are not supposed to associate the company with its own members. But the exceptional circumstances may come to ignore this separate legal personality part of a company and to establish the the what lies behind that separate legal personality. And that can be through a statutory requirement, or there can be an exception through a case law. For instances, um, for instances of fraud, or maybe there is need for investigation and all that. Now let's look at um, some of these exceptional circumstances that depart from the general rule of separate uh, legal personality of a company. So, Section 67 of the Companies Act looks at lifting of the corporate veil where there is non-publication of a company's name. So, a company is just operating on its own, and it's operating, but it's shielding it itself from the way it is operating. It's not is not specifically showing the place of operation of their business. They are not showing the name and things like that. Even if somebody else is using the name of the company to run it their own affairs, the law may uh, disregard the incorporation part and look beyond to see if there is someone else who is running behind the curtains to use as the company as their own agent. So a company if being misused as an agent of a person, then we can pierce the corporate veil and then lift it to see if there's anything beyond that veil. Sometimes we also lift the corporate veil where there are group accounts of a company, especially where we have the holding company or the parent company is operating the same account with the subsidiary. And that can be for the purposes of taxation or for the purposes of establishing even the control of that particular company. So if we establish that the control of that company is not by the subsidiary is not in control. It may be the parent company is totally in control, and we want to find out that, then we will pierce the corporate veil. That means we are going to move from the subsidiary and look beyond subsidiary. Who else here is controlling this thing? Who is calling for shots? And then we say we have lifted the corporate veil to look beyond. And then at some point they might find that the parent perhaps is in control, or if it's for the purposes of looking at the accounts um, of a company to establish the taxation. Maybe a company is established in UK and it's operating in Kenya through a subsidiary. um, then we will say that if we pierce the corporate veil, we will look beyond and see maybe where the money is flowing from and how we can tax such kind of a company. We may also lift the corporate veil through the statutory exemptions, and that's one of them will be with regards to investigation into the company affairs. To some extent, we may have um, the company affairs being maybe maybe done, or maybe uh, there is illegality which is going on that the investigating officer wants to find out, and that will be looking beyond the company itself. can we now look behind it? Maybe some money has been coming to the company through illegal means for the purposes of money laundering, for example. So if it's in something like that, then investigations being carried out, we will want to see beyond this company, where is this other money coming from? Perhaps the money is coming from a shareholder who is out here. Remember, this is an incorporated company. This is the corporation or the company that we're saying. And then here in the middle, we have the veil. We will now pass the veil here to go to shareholders. In as much as we say that members of the shareholders or the owners of the company will only be limited to the liability, which I mean to limited liability to their capital subscription, and also they are not supposed to be associated with the company, and that's why the company is a separate corporate body. But if there is need for investigating these shareholders, we will bypass this veil. We will disregard there is a veil in between the company and this, and then they now make an investigation, not just for the corporation itself, but they will break this veil and go to the shareholders and see how the shareholders have conducted themselves, if it's in a fraudulent manner or if it's in a way that um, uh, obstructs justice, or maybe in a way that it's maybe conducting maybe money laundering or something like that, then investigation will not stop at the company, will not stop at the veil, will go beyond the veil to look at the shareholders. Um, so Section 1002 also provides for the fraudulent trading. If the company is providing for fraudulent trading, they can also be investigated. The veil can be unmasked so that we can maybe look at what the shareholders are doing with regards to the company business. So that's it for now for this second lecture. And thank you very much. Our next lecture will be lecture 3, which will deal with alteration of company status. And also, we shall look at foreign companies. How are they formed in Kenya? So thank you very much and see you in the next lecture.